So let's see. Next week. So we're gonna have an agenda, pretty much basic questions, the sponsors, me as your hero. So talk about the legal corporations and the claims, the tools and forms you're gonna need to make that happen. Some basic understanding between the difference in the U.S. codes, the federal rules of civil procedures, local rules, and case law. And the motions associated, what you gotta do to be successful, at least to fight back these legal corporations, the costs and times associated, the differences in jurisdictions, the difference between the legal cases and the appeals, the judges, magistrates, and judgments, and then we'll do some speed running. What happened based on those tools that we learned. We're gonna run with this. So again, our Galactic sponsors, a special thanks to all our sponsors. Great job, Pragmatic Institute, Texas Maycom, and 280 Group, and the Norris Group down there. So thank you for your sponsorship and this great event. Also to my stakeholders, I have a lot of people in my legal cases, and all of the individuals have contributed and helped in their own shape or form, and our institutions, and from the administrators to John Cornyn and Lizzie Fletcher, representatives here in Texas, both Democrat and Republican, they're really cool, and the other individuals here. But we're going to talk about the galactic legal questions, what you're here for. So if you're being censored, which is now kind of a thing going on, like I got censored in LinkedIn, and you may not be the only one getting censored, or your products from a product manager perspective, your products being, illegally attacked, from an ethical corporation. Yeah, the corporations will, if you're successful, they will sideswipe you. So are you ready? Do you have a budget or a limited budget? Are the bar lawyers refusing to defend you due to fear to the competition, or because they want to, work for the, when I talked once for Disney, a lot of them said, they either worked for Disney before, or they wanted to work for Disney, so they didn't want to represent me. Or that could also be the case for you. Now, do you have $50,000 budget, to do a few motions? And that's on the low price. Some of these lawyers charge way more. Can you single-handedly handle an army corporations? Do you know what to do? File a complaint or a motion, or the costs associated? So we're gonna really talk about that, how you do it yourself. So first of all, I'm Alejandro Perez, and here's my disclaimer. Look, I'm not a bar lawyer. I'm not here to sell you anything, and I don't want your business. I only want, I'm only a veteran pro se plaintiff, and I'm only sharing my multi-million-dollar experiences, in this legal cases. So pretty much you're coming along for a ride. I'm going to teach you how to do it yourself, and you have to be in this situation. So again, pro se plaintiff means you are your own lawyer. You have no lawyer. You are doing it yourself. So when you're joining my session, we're really going to explore how to fight back as a pro se plaintiff, as your own lawyer, against unethical corporations within a budget. So you can do it with less than $5,000, and that's a good thing, because you don't need to be paying all that money if it's obvious. So let's make that happen. So I sued LinkedIn for $2 billion. That's the appeal number, and the Walt Disney Company twice for a total of $200 million. So who am I? Well, I'm a man after God's heart, a U.S. military officer, a PMP, like Smith over there, inventor, honorable war veteran, author of controversial novels. And again, I'm here to teach you how to be your own pro se lawyer and fight back. All right, so who are the evil corporations? We have LinkedIn, and those are the 3 cases so far. Here's my basic claims, and claims that you will eventually have to do on your own, but I will teach you a few tricks here and there. But, I've said that the corporation erased me for the Chinese Communist Party. The violation of the laws was anti-SLAPP law, section A and E, and the cause of action, intentional infliction of emotional distress, which means they're just being jerks. And we started with $250 million, and we're right now finalizing the $2 billion in there. That did change, but we'll just keep moving there. The Walt Disney Company. So for them, it was copyright infringement and conspiracy to restrict trade. Those are the US section codes that you could use if you're in the same or similar situation. Again, intentional infliction of emotional distress, they're just being jerks, and there's 4 criteria, and there's case law behind that. We started with 100 million, and we're finalizing the 200 million plus. So welcome. That was the controversial novel that I wrote, The Real North Baiters, and that's how I got into the Walt Disney. But are you ready for the legal games? That's the real question here. So here's the tools you're gonna need to be able to defend yourself as your own pro se plaintiff. If you ever find yourself that you don't have the lawyers, they don't want to come to your rescue, and you don't have millions of dollars lying around to throw to lawyers that do want to come to your rescue. So you're going to need pro se form number 1. And, there's the link over there. You can use it and find it. And there you have to write your claims, which is a combination of loss, violated, and the cause of action. There's, you can check it out there, the link. Next is the cover sheet. You will need a cover sheet. It's a court admin form. You will need that yourself. Just basic information. And there's the link. The summon. Here's a little. This one's a little interesting. This is how you get the lawyers to come to you from the evil corporation, whether it's Disney, LinkedIn, or whatever corporation is trying to, put down your product or your profile. 3 steps. So you got to get it signed by the clerk, the court clerk. You got to get a copy from it. And then you have to return it back. Well, you have to email all the copies to the defendant and then get it back to the certified mail. And that's how you get that done. Now, you also have to file 1 letter of interested parties. Now, you can freestyle it, you can go recycle it, as you see in the CAD form. And this is more about who you are. You have to identify yourself to the court and say, hey, I am so-and-so from this corporation, or you so-and-so as an individual. If your product is an individual product, you have your copyrights assigned to yourself, that you may have to represent yourself as an individual. If your intellectual property is assigned as a corporation, you will have to file as a corporation, as a letter of interested party as yourself. Next things you have to do is go check out the local rules and forms. That's, each website, each federal court will have their own website. Next action, you will have to review these local rules. You have to go in there and find out about them. Then you have to, ingress your information. Now, some courts allow you to do it online, and some you'll have to do manually or by mail. And that will take, it's not impossible. And yeah, we'll talk about the cost, what are the costs you will have to pay to defend yourself. But, we keep moving. And also there's some local forms, like the CAD, for example, is the Central District of California. They have their own little forms that you have to check it out. It's little things like that they throw out. But if you want to defend yourself against multi-million-dollar corporations, you're going to need these forms, and you're going to need these tools, and you're going to need these processes. Let's go for the next one. There you go. Also, you'll have, there's a lag. You'll have to create a Pacer account, and you have to create yourself a CM-ECF account. The Pacer account is where you do your payments to the courts, and you have a portal to all the different CM-ECF. You're going to need that. You're going to need access to all that information and to the account to pay for the filings yourself. Again, this is pro se. You're doing it yourself. You're fighting the big man. This is Goliath, David and Goliath. You're David. I'm giving you this link and give you the rocks, but you still got to go hurl it yourself. And the other thing you need is the CM-ECF account. Here are the documents and filing systems per jurisdiction. Each one is different per jurisdiction. Now you have the ability to view your cases, both the lawyers and yourself. You can view your own case in your own dockets, or you can even get the rights to file, which is pretty cool if you have the rights to file your own stuff. Again, this is pro se. This is do it yourself. So if you can file your own motions, file your own complaints, file your own things without going either by mail or in person to the court to drop it off, it's a good thing. Plus, the quality of the images is much better. But again, you can have either restricted access, which is going to look like this. You can only query and report, which would be only, or you have full access. You can file, do more reporting and do other things. Again, this is do it yourself, fighting big corporations. So the galactic hierarchy here going on is you have to start with US codes. What actual codes got broken? It was a US Code 15, there's an Section 1, antitrust, conspiracy to restrict trade, or US Code 17, Chapter 5, copyright infringement. You have to declare what law got violated, in part of your claim. So you have to be very good about the US codes associated with your product or your intellectual property or yourself or your profile. Also, the federal rules of civil procedures, these are very important. This is how regardless of federal rule, regardless of court, all these federal rules have to be followed by every federal court. So, these are the most important ones. Number 12, answering dismissing of the case. That's what they're going to hit you with, the defendant. Number 15, the amended complaint. This is very important because it allows you to, change your complaint, because you may not get it right the first time, and you may have to amend it and change your complaint. This is how you get them. And you will be allowed to use that rule, and you summon it. You say, hey, I'm using federal rule number 15 that you can change whatever the defendant's saying, and you can it's like a redo. So it's a very good thing to know. And then default judgments, that's when they don't answer anything, you can default and try to win that route. And we'll go more into deep detail into the motions, but I'm just giving you what federal rules of civil procedures are if you've never seen it in your lives as a product manager and you need to defend yourself. Summary judgments is what you're probably gonna defend yourself with. You don't want a jury, you don't want all that stuff. You want to summarize. And we'll talk more about that later, but that's a key one. Number 56, summary judgment. That's going to be your number one. Local rules, yeah, each jurisdiction, like the Texas Southern District, is different from the California Central District courts. Each jurisdiction is more lax or more about their local rules. Do they want a certain kind of hole puncher? They can get ridiculous like that. Do a hole puncher, So there's extra rules and forms you do have to check out. And like I said, you do have to do those steps. And there's case law. Now, case law is the bottom of this hierarchy, but the one that says, what did other courts do? And there's case law that's in your favor, you as a pro se plaintiff, you who will have to defend yourself against multi-million-dollar corporations. This is what you need, and you need to put that in your motions. And we'll talk about more motions, but here, for example, in Hines versus Kirshner, the pro se plaintiff, you defending yourself, in other words, pleading request and motion should not be dismissed. So you can say to any judge and show up, hey, you cannot dismiss my request for motions, or you cannot dismiss me because of Haynes versus Turner. It's right there. And then you can do the same thing with the other case law. Hey, you have to construe broadly. In other words, you have to let me freestyle it a bit. And every reasonable and warranted inference in your behalf in favor of the plaintiff. In other words, they have to do everything possible in your favor. So these are things you may want to have in your motions, and we'll talk about that more. And other things like, hey, if you're the big corporation, you can make him come to you. We're using International Shoe Code versus Washington. You can say, hey, big corporation, we're going to use the long arm stature of personal jurisdiction and bring you back in to my jurisdiction in order so I can take your money because you're evil. That's what you can do with these things. Case law also from the copyright and summary judgments, Rossi versus the Motion Picture Association of America. So in this one, it's very good because if you're a copyright holder, how many, okay guys, so we have a small group here, which is fine. The smart people that wants to defend themselves against multi-million-dollar corporations are here. So how many of you have intellectual property in your company? Christina, E.H. Connors, Ian, or Sunil? Any of you guys have any intellectual property that you own or your corporation owns?
I don't, but I work with R&D groups, and they do present create a lot of IP.
Perfect. So in this case, in Rossi versus the Motion Picture Association, the Motion Picture Association had the copyrights. They owned the copyrights, and Rossi did not. But the Motion Picture Association was allowed to make a summary judgment, which is what you want, to get to the point. The summary judgment is just get to the point. Let's forget the jury trial. Let's forget everything. Let's get to the point. And that case says, hey, you can get to the point very quickly with any corporation if you own the copyrights. Or in your situation, if your corporation owns the intellectual property, you have a right for a summary judgment, and that's a good thing. That's a very good thing. And more about summary judgment is how if there's no if you own your copyrights and they can't prove otherwise, or you own your intellectual property, they can't prove otherwise. There's no material fact that you're entitled to. And we'll talk about that more, why you want that. So why the summary judgment and why put so much effort on this? Your summary judgment is your primary attack tactic. It's your speed run. How many of you guys have ever seen a speed run? Does anybody know what a speed run is?
Nope.
All right, speed running is when professional video game players can knock out video games that normally take hours into minutes. So the guys that beat the Mario Brothers or the original Zelda in less than 30 minutes. Games that would take days and months, they can knock it out in 30 minutes. So this is the motion for summary judgment is your speed run. It's the thing that cuts is so fast that all you're really doing is asking for a judge for a quick judgment and avoid the trials BS. All that other stuff gets avoided, and you're just getting straight to the point. This is the most important thing of your legal career. So everything Federal Rule 55 is what you need, especially if the facts are undisputable. Again, if you own your copyrights or you own your intellectual property, you're entitled to this. You're entitled to a speed run. This means that instead of years of a lawsuit, you can knock it out in days. And I'll show you that in a moment with actual evidence. And, some of the case behind it, again, copyright holders are entitled for summary judgment. You do have to provide a proposed order with it. And do cite, the US codes, the federal rules of civil procedures, the rules, and the case law to back up your argument. This is your number one. This will speed you up. This takes a case that takes years into months. You have to oppose the motions. So the defendant will throw different motions at you, and you have to be able to block them. You have to answer within 21 days, have a proposed order, and cite as much US code, federal rules of civil procedure, local rules, everything you can. And replies. So each is, who here has ever done debate? Has anybody here ever taken a debate class? Nobody's taken a debate class? You've seen it?
Is not.
Wow. Okay. So in debate, you have.
I've never done it.
Nobody's ever done debate?
I've never done it to class, but I do plenty of debates with people.
Okay, so
Yeah.
there's a formal structure, everybody, who knows the formal structure of debate? There's a, rebuttal. You ever heard of those words? Make your argument, rebuttal, and then rebuttal.
No, but this is interesting that actually there is a class about it. Didn't know that.
Holy smokes. Okay, so anyway, so there's in normal debating, there's a 3-step process.
One couple before this, they died.
And the point of the matter is, like, you're able to answer back and hit back. It's a 3-step process. So you can, attack, block, and then, attack again. And they do it from different sides. 3-step process. But the whole point is more motions. Motion to strike, that's what they're going to do to you. And they're going to try to do a motion to dismiss. So when you're trying to defend yourself, that where you're in the offensive and they're trying to defend themselves, they're going to try to do a motion to strike and a motion to dismiss. They're going to try to get rid of it. All right. They're going to use this 2 right here. That's what they're going to do. So there it is. Those 2 right there. And you can counter by amending your complaint. This is why that Rule 15 I mentioned earlier is important. This is how you can counter. You can block this 2 simply by saying, hey, thank you for the feedback you gave me. Thank you for everything, all that information. I'm going to change my amend. You have to refile a new motion to dismiss and a new motion to strike. And again, the motion for summary judgment is the best one you can get if they never answer. I feel this is more of a theory than an actual motion, because it's so hard to activate. There's a lot of legal procedure and jumbo to have to move this stuff. And I filed it and everything, but they don't always recognize a motion for default judgment. So, but if you can pull it off, pull it off. And this Rule 55, it's winning by default. If you sue a multi-million-dollar corporation and they don't show up, you win by default. But you have to use this motion for default. But I almost pulled it off with Disney, but the court, long story short, and we'll talk about that later on because I got to show you what happened. And then there's motions to extend time and motions to transfer. There's other motions, but they're not that important. Again, your big money maker is going to be this one, a motion for summary judgment. If you learn anything in this, there's a walkaway, motion for summary judgment. That's what you need to get to. Actually, we did talk about the cost and time. So let's talk about that. Your initial filing might be around $400 plus a few $100 for certified shipping mail. So we're talking about a very low budget that you can pull this off. I show you the forms. I show you what the basics of what you got to do, some of the motions and most important things. And then you got to pay these people. You got to pay, the initial filing, for that, pro se form, the cover sheet, the settlement entry letter, and whatever. The Pacer account and the CMSMF, which is where you file your documentation. No additional cost, but you do have to ask, to get in there. And then each jurisdiction does have some extra costs here and there. But if for less than $1,000 per case, you could defend yourself against a multi-million-dollar corporation. That's kind of the point I'm trying to get here. Jurisdictions. All right. So jurisdictions are important because each one has their own style. Federal rules might apply to all of these jurisdictions, but each one has their own little thing. So prior agreements really determine, jurisdiction. Did you a lot of this into your products, you might enter into contract agreements with your clients, and you have the right to change venue to your preference. But sometimes when an evil corporation shows up to censor your product or you or whatever you're trying to do, you may not have prior agreements. And this is pretty cool because it allows you to kind of be a free bird, and where do you operate? So it becomes more of a, okay, we have no prior agreements. I don't even for example, with the Walt Disney Company, I have no prior agreements. LinkedIn, I did because the user agreement, and I had a LinkedIn profile. So in one, I had a prior agreement, and the other one I didn't. So I was able to do more with the Walt Disney Company because I could determine my jurisdiction. I can go whatever court I wanted to go to, versus I was forced to go into a court with a prior agreement. And all of you have signed that, even signing when you join your employer. If it's like almost at the very bottom when you sign a document, there's always a, hey, which court venue, and you've seen it. If you write any contracts or your products, go look it up. You have a venue agreement, a venue clause. And if you don't have a venue clause, go at it. Again, I'm not selling anything to you guys. This is more of what you guys got to do to prepare yourself. And the venue agreement in your clauses or in the clauses of people that are erasing you will change what the jurisdiction will be. All right, so the difference between the district cases and the appeal. So the district cases, you'll have one federal judge, one magistrate, lots of motions. Is very freestyle. It's the Wild West in the federal district court. That's why I say just go for a motion for summary judgment. I said that's the only thing you got to do. That's the only thing you got to remember. Remember that. And because it's going to be freestyle, there's going to be so many things going to throw at you. Just go for the motion for summary judgment as soon as possible to save yourself all the time and trouble. The appeal cases are more structured and simpler. There's 3 federal judges, and it's a very strict format. There's only one opening brief, one answer brief, and one reply brief. That's it. In comparison to the federal district court, this is very structured and very simplified. And you'll be talking more about what went wrong to the case versus in a federal case, you're talking about more about what was violated and what was the cause of action behind it versus what went wrong with the case. And was, for example, obsolete case law, obsolete applications to the law, incomplete motions, federal rule civil procedure violations, that kind of thing. The judgments and the judges. So each one, has one federal judge, and each one gave me a different answer on very different things. And those are the other ones as well. I'm just kind of showing you this is who they are, and we'll talk about them more in a moment. Federal judges, they prefer motions for summary judgment as well. So it's a combination. You want a summary judgment because they also prefer a summary judgment. Why? Because it takes less than 4 to 6 months to get to get that information, or less than a few months to get a summary judgment and get a federal court. Obviously, there's magistrate judges, and they can affect your court. They could actually lag it on, make it longer. And some are cool, some are not. So be careful with them. Make sure you never sign any of them. All right, ever. Just go for the federal judge. That's the most important thing, and go for the summary judgment. All right, so are you guys ready for the legal games? So what did happen? So in this LinkedIn SPACEJAM round 1, I was able to file a complaint form, and in 110 days, think about that. In less than 3 months, I had a federal judgment. Not years, they're like, oh, the minute, it will take forever. No, there's not years. You can pull it off in less than 110 days from the moment I filed a complaint, like I showed you those forms, to the moment to get a federal judgment is 110 days. You could pull it off. Now, I may not be the best writer in the world, but it's 110 days. Samita, if you're still there, from a project manager perspective, 110 days, that's a quick comparison. Now, they did give me a redo. They get dismissed it without prejudice and to go to the Northern District of California to change venues, like we talked about earlier. But again, from complaint to end judgment, 110 days. So if any lawyer says, no, it takes years, that's BS. You can pull it off as a pro se plaintiff in 110 days. So I went for round 2, I didn't like the decision. I mean, they gave me a redo, that was cool. And they dismissed me with prejudice, and we can go, I don't want to go into details of the case because is more about how to, you'll have your own case, about you having your own case. So I'm not going to go much into details. But the point is, for a second case, from the federal complaint, me filing those forms that I showed you, 120 days, you can get yourself a federal judgment, a judge answering, again, so 110 days, 120. We're averaging this. So in less than a year, I was able to get 2 federal judgments. Think about that for a moment. When they tell you that, the court takes forever, not if you do a summary judgment, if the facts are very obvious, you can pull it off twice in less than a year. Now the appeal, I appealed it. I never done an appeal before, but they cheated me. But long story short, from the moment I appealed the case to the 3 judges above, like we talked about the structure, the 3 simple structure with the reply, the answer, reply, well, the reply, the opening, the answer, and the reply in the appeal. But the simplicity here is that the moment you do a notice to appeal plus 283 days, you can get a federal appeal judgment as a pro se plaintiff. You can pull it off. I mean, if I can pull it off, you can pull it off. So this is less than a year, which is pretty good because appeals can take years. So I just show you that you can, with the tools that I gave you, you can go pull it off, and in less than a year, you can have an appeal for yourself. Now, this was kind of interesting. When Disney, when they censored me for my novel, this one got a little weird because, again, the magistrate judge got involved. So from the moment I filed a federal complaint, I'm probably going to go into a trial or a pre-trial order. I have to file a pre-trial order, and we're just going to have probably a paper trial. That's what they call it. But this one's going to take a little bit longer because the magistrate judge kind of messed it up for me. But here's even cooler. Again, what a summary judgment can do for you is that I filed again with the Central District of California. And again, filing a federal complaint in a federal court plus 71 days got me a federal judgment from the Honorable John F. Walters in the Central District of California. And for the first time in my life, I got something that isn't a dismiss. He said, stay, granting in part and denying in part, and waiting for the Texas Southern District. So not all judges suck. I'm kind of just passing that on to you. Some will, they won't dismiss you outright. They may even stay. Eventually I'll hope that they grant, which is here's what you want to do, to grant. I may not be the most charismatic. I may not be the most beautiful. I may not be the most persuasive in a legal argument, but maybe you are. And I just gave you the tools for you to pull it up and show you that the moment you file a federal complaint, plus 71 days, you can get yourself a federal judgment. So the question really is, are you ready for a legal speed run? Can you pull it off to go out there the moment you file a federal complaint and, to defend yourself, defend your products, defend, your profile and your intellectual property, your IP of your corporation or your personal IP corporation. We're running out of time, guys. So, we're actually at the end of the presentation. I do hope you enjoy what I presented to you and the tips I gave you. Does anybody have any questions, comments, concerns? I know it's a lot of information, but open to the floor.
Bit of related question maybe. Are you familiar with rhetorical? They stopped teaching that in schools. Is that part of the debating class that you were mentioning it?
Rhetorical questions are questions that don't normally have an answer, but this is not about.
No. It's something that we're teaching in school before the 19th century, right? And it's the way people should behave in a society, and has to do with politics. And the greatest speakers actually studied rhetorical.
Yeah, that's okay. So can we keep it within scope of you as a pro se plaintiff defending yourself and does anybody have a question about being a pro se plaintiff and defending yourself against multi-million-dollar corporations if you want to do it yourself? Do you think I presented enough information to pull it off yourself? I mean, forget about rhetoricals. Let's not waste time on that. Let's focus on what's important. You defending your intellectual property, you defending your product. Do you think the information I gave you to pull it up?
How do you respond to discovery?
That's the beauty of the summary judgment. If the facts are obvious. That's a great question, by the way. I'm not like, that's a good question, as a matter of fact. If the facts are obvious, if the facts are undisputable, you're entitled to a summary judgment. So you can bypass discovery simply by saying, hey, the facts are obvious. Here's my copyright, or here's my, patent, or here's my whatever. I'm entitled to a summary judgment because they don't own this. That's their fact. And there's nothing they can change that unless they buy it. And they haven't bought it. So, you can do stuff like that. Say, hey, if the facts are undisputable, you can avoid discovery. You can avoid a trial, man. You want to avoid that stuff because that takes forever. That's why I do recommend the summary judgment. It is your speed run. It is the fact. Does that answer your question?